Hello. So tonight we are making a butterbell. If you don't know what a butterbell is, I'm sorry for you, but you should look that up because butterbells are awesome if you consume a lot of butter like I do. And we are going to talk about how do you copyright your work? That's a question I get asked a lot. How do I copyright my work, Amanda? And I say, you don't. You don't copyright your work. You own the copyright in your work from the moment you have fixed your creative idea into some tangible means of expression. So when you've snapped the picture and it becomes a digital file, then you own the copyright right then. You don't have to do anything. You are the copyright owner. You made that work. So what people really usually are meaning is, how do I register my work? Or should I register my work? Is there a reason to register my work since I own the copyright? And yes, you very much should register your work, and you should register it before you publish it, which is a whole different topic. But you should register it before anyone else has a chance to infringe it, because if you do that, you have a lot more, a stronger case and a better ability to recover damages if you go to court. So if you have registered your work, and then after that somebody begins infringing it, then you can seek what are called statutory damages, which means damages set by the statute. You don't have to actually prove exactly what you've lost by someone stealing your stuff. And statutory damages can go up to $30,000 per infringed work. If you can prove willfulness, so sort of bad actor, then you can get up to $150,000 per infringed work, which that's substantial. And you can seek attorney's fees in the litigation if you win. So that's a huge thing. A lot of attorneys don't take these kinds of cases on contingency, and the reason is because it takes a lot of money, time, and effort to litigate a case through federal court, all the way from pleading to trial. And even though most cases eventually settle, you still have to go through the hoops of usually some discovery, sometimes depositions, and all that adds up. So federal litigation is not cheap. If you can recover your fees from the other side, that makes your case a lot more attractive. Attorneys can take it, because frankly, it doesn't make sense for you to pay an attorney their hourly rate to litigate a case when you're only going to walk away for a few $1,000s. You're going to spend more on attorney's fees, and an attorney can't take the case and work for 3 years on it on a contingency basis and then get paid, a couple grand at the end. Like, that's not a viable prospect for anybody. So the better choice is, if you've registered your work, then when you find an infringement, you have all those tools at your brain's not working. You have all those tools available for you. So that is one of the reasons why you also, you have to register your work in order to file suit in the United States. So you can't just, if you haven't registered and then somebody steals from you, then you can't just go right ahead and file suit and just say, oh, well, I'm just going to take a lower amount of damages. That's not an option for you, because the law is now that you have to have your copyright registration certificate in hand. Sorry, we're measuring a different butterbell. You need to have your copyright registration certificate in hand before you can file suit. That one's taller. Maybe make this one a little taller. So the Copyright Office doesn't necessarily act as quickly as one would hope when you're waiting for that certificate to come in the mail or email. So let's say you discover an infringement and then you're not sure what to do about it. So you think about it, you get angry about it, you go to a bar and drink to your friends about it, and then eventually you're like, well, I should talk to an attorney. And then you're not sure who to talk to, and all of this time is passing, right? So eventually it's been a couple of years. Maybe you got busy, maybe COVID happened and you got stuck in your house for a couple of years, and the Copyright Office started moving even more slowly. So let's say finally it's been 2.5 years since the infringement. There's a 3-year statute of limitations on copyright claims. And so you're like, that's fine, still have 6 months, but you don't, because you have to have that certificate in hand before you can file. And if you have waited till the last minute, you are going to have the worst time waiting and hoping to God that the Copyright Office is going to get your certificate to you in time for you to file and not lose your entire case because it took them too long to process your stuff. And yeah, you can pay an expedited fee and all of that, but expedited isn't really that expedited, and you really don't want to be at the mercy of a government agency moving quickly to be able to enforce your rights. So register your work with the Copyright Office, and ideally do it before you publish or within 3 months of publication. And then you don't have to worry about waiting around for the Copyright Office to do something. And you're more likely to be able to find an attorney to take your case. And frankly, from the defendant's perspective, if they know that you've registered their work and they're going to be possibly on the hook for statutory damages and attorney's fees, you might not even have to file a suit because they're going to look at that case and go, woof, this could get really expensive really fast. We should just come to the table and offer a reasonable settlement. So that's why you register your work. It's already copywritten.